Lil Durk'S legal team asked the judge to split this case apart or throw out part of the indictment together, but the federal government just fired back with a 30-page response, and buried inside it are claims about encrypted phones, alleged witness intimidation, new evidence and messages prosecutors say explain why this case should stay together. By the end of this filing, the government leaves the judge with screenshots they clearly won't remember, so let's go through what they actually filed. Into all of it because we could be here all day. It is a 30-page document, and I ain't gonna lie. Y'all know I like to read because I've just learned how to read, hooked on phonics for a minute. So, Memorandum of Points and Authorities Introduction. This prosecution arises from a coordinated gang murder. At approximately 6 a.m. on October 24th, 2024, the government executed simultaneous warrants and arrested defendant Banks' 5 co-defendants in and around Chicago, Illinois. Soon after, defendant Banks began booking international flights in an apparent attempt to flee the United States later that evening. The FBI arrested defendant Banks before he boarded a private flight out of the country, and he and his co-defendants were subsequently charged in the first superseding indictment. The FS1 or FSI, however you want to say it. The FSI outlined the gang-related nature of SR's murder and identified multiple uncharged co-conspirators who conspired to kill TB, resulting in SR's death. As a result, the government continued to investigate the conspiracy and other criminality linked to defendant Banks and his co-conspirators. That investigation involve robust legal process and the review of voluminous digital records with 59 digital devices and accounts seized, including 38 following the defendant's arrest. The investigation also revealed the co-conspirators' tradecraft in attempting to evade law enforcement, including witness intimidation, their use of multiple burner phones, and messages showing instructions from enterprise members to delete communications, including defendant Banks telling co-conspirators to delete thread and start new one after suspecting an individual provided information to federal law enforcement. Based on the government's investigation, the grand jury returned additional charges in the third superseding indictment, TSI, on January 3rd, 2026, including Vicar murder charge. The government doesn't ease into this filing. They open by reminding the judge what this case is about. Prosecutors write that after the October 2024 arrest, the investigation didn't stop. They say it continued through digital devices, electronic records, and additional evidence they believe tied everything together. Right away, they're framing this as an investigation that keeps growing after the first indictment. Now, here's where things get oddball as hell, and I got to give it to the feds. When they do something good, we will point it out as far as trying to make their case. So we go down where they start talking about all the shit that Lil Durk wanted. Court-ordered trial continued to October 14, 2025, and made excludable time findings under the Speedy Trial Act for all defendants. Then it says defendant Banks filed a motion to dismiss and all of that stuff. But then here's where it gets effing crazy, right? Where's it at? Because they go on to say that this is horrendously bad. April 16, 2026, Anthony Montgomery Wilson pled guilty in the Northern District of Illinois to use of a firearm during and in relation to a crime of violence, murder for hire for murdering SM, as consideration for the promise and agreement to pay a sum of money from individual C. Defendant Montgomery Wilson further admitted under oath that after murdering SR, he collected money that had been offered as consideration for SM's murder. Then it goes on to say May 13, 2026, government informed defense counsel that it was considering filing a superseding indictment before trial that would make the Chicago murder of SM and the attempted murder of AW in Georgia relevant as direct evidence at trial. Preston Powell pled guilty in the Northern District of Illinois to use of a firearm during and in relation to a crime of violence, murder for hire for murdering SM. Among other things, defendant Powell admitted there was a cash bounty for SM's murder and that he participated in a conspiracy with Montgomery Wilson to murder SM and to collect the payment. Then the government confirmed to the defense counsel that it will supersede with Vicar murder charge by June 3rd, 2026. Then it says by June 3rd, 2026, we did that. This is where prosecutors explain why the indictment changed over time. They argue they didn't just wake up one day and add charges. According to the filing, investigators continue reviewing encrypted devices, electronic evidence, and information from cooperating witnesses. Their position is that the later charges came from evidence uncovered during that continuing investigation. So we finna sit up here and screw you about this shit because we didn't stop the clock from tick-tocking. Roll it. Government's investigation and superseding charges as set forth above, after learning that defendant Banks had booked multiple international flights following the arrest of his co-conspirators, the government arrested defendant Banks and charged the defendants in the FSI. As a result of the arrest and other search warrants executed in or around October 2024, the government seized a significant number of digital devices. Following the arrest, the government continued to investigate uncharged co-conspirators and other criminality linked to the Banks gang enterprise, including through proffering multiple cooperating co-conspirators and by seeking additional warrants to search for and seize evidence related to RICO and Vicar, hereafter enterprise evidence. As the government continued its investigation, including its review of voluminous electronic records, it found significant gang enterprise evidence. Among other things, the government identified numerous text messages by and between enterprise members discussing the racketeering activity alleged in the TSI, including communications about identifying suspect informants, among others. For example, in August 2023, defendant Banks sent a group text message to co-conspirators and enterprise members, including defendant Wilson, stating that a suspected government informant and shooter during the 2022 Los Angeles murder of SR was just ready to snitch, blood clear as day, and he gonna tell soon. Defendant Banks then reassured the group, sending a follow-up text that stated, as long as we don't break, they can tell him whatever. Then they talk about this in the footnotes. Example, in February 2025, the government sought and obtained rollback warrants to search for the enterprise evidence dating back to 2019 from iCloud accounts belonging to co-conspirators 3. And in September 2025, the government obtained warrants to search a social media account belonging to defendant Banks, 2 contraband devices that defendant Banks used to have unmonitored communications while incarcerated, and iCloud accounts associated with defendant Banks' contraband devices. To date, the government has produced approximately 4.5 terabytes of digital evidence from approximately 59 digital devices and accounts. But that's a little odd because they're basically saying that we looked at all this shit and this is the unmonitored shit while he was incarcerated, but it doesn't produce anything that says he actually said anything that's effing insane or crazed. You know what I'm saying? So there's that. Now we get to the heart of the motion. Durk's side wants certain counts separated. The government says no. The argument is that all of these allegations are connected as part of one alleged enterprise. Splitting them into different trials will keep the jury from hearing what prosecutors say is the full picture. So there's that part. Then we go on to see evidence collected during the investigation also showed that enterprise members took significant steps to prevent law enforcement detection and conceal evidence. For example, in a July 2023 group text message thread between defendant Banks, co-conspirator 6, and other Banks gang enterprise members, defendant Banks instructs the group to delete the text thread and start a new one after co-conspirator 6 sent a voice-recorded message to group suggesting police have recently arrested someone and were asking about defendant Banks, co-conspirator 6, and Banks gang enterprise members. Co-conspirator 6 then sends instructions to the group on how to further conceal evidence by deleting text messages from cloud storage. Additionally, the co-conspirators often use multiple burner phones and would dispose of these phones after violence to prevent law enforcement from obtaining relevant information, as defendant Banks did after SR's murder in Los Angeles. So they're basically saying, yo, Durk, your ass, you ain't as innocent as Ceddy Nash is saying because, bruh, you were telling people to go ahead and delete all of that shit. Then the filing shifts away from legal theory and then the practical concerns. Prosecutors tell the judge there have already been threats and public intimidation directed at cooperating witnesses. They argue that forcing those witnesses to testify in multiple trials would increase the burden and the risk. That one of the reasons this shit should stay together is so that the snitches, the rats, the informants, Don't have to keep on popping up back and forth to goddamn trial. Let's keep it all together. So that way this lie or truth that they possibly could tell can stick this one time, because it's such a dangerous enterprise. Remember when they were hollering, oh, the judge got threatened, oh, and all this shit, and it was overzealous, oh, and then nobody was prosecuted for that. But let's keep on going. Then we go on and they talk about the murder of SM in Chicago, January 27, 2022. Among other things, after murdering SM, the Chicago defendants Montgomery, Wilson, and Powell discussed collecting the bounty for killing SM from defendant Banks and the Banks gang enterprise. Specifically, defendant Powell sent a text message to Montgomery Wilson stating, "What's up with OTF? What you mean they not paying?" In response, Montgomery Wilson wrote, "We waiting." Defendant Banks comes up here on the 17th. See TSI at introductory allegations. The attempted murder of AW in Atlanta on February 5th, 2019. As alleged in the TSI, the alleged attempted murder involved multiple enterprise members, including defendant Banks and DB, meaning King Von, and began as a coordinated botched robbery attempt. And that's not even true. That was really some shit where King Von and Lil Durk had nothing to do with that shit. Somebody else did, and it wasn't no damn robbery. It was, bruh, you owe me some shit, and I don't care, I'm gonna beat your ass for it. And then it got a little bit crazy after that. Argument. Defendant's sole basis for severance is that the joinder of the Vicar charges at the August 20th trial would imperil speedy trial rights under the Sixth Amendment. That constitutional analysis is factually and legally unsupported. Ninth Circuit law compels a joint trial on all properly joined charges in the TSI, which will ensure a streamlined and orderly presentation of evidence, conserve judicial resources, and minimize risk to witnesses. Holding two trials, including one that pretends the enterprise allegations do not exist, would deprive the jury of a complete understanding of the alleged gang enterprise, including how and why the Los Angeles murder occurred. The government also pushes back on the claim that the case is taking too long. Their position is that much of the delay came from continuances requested by the defense or co-defendants, not from the prosecutors dragging their feet. In other words, they argue the speedy trial claim doesn't fit the history of the case because we didn't ask for any of this shit. Y'all asked for it. And now that we basically sitting here and letting y'all fry each other and turn on each other, you can't now go, well, I would like to get this back on track. No, you asked us to slow it down. So don't try to ask us to speed it up and then basically say it's illegal what we're doing when your lawyers agreed, the judge agreed, we agreed, we a family, we stuck in this shit together. What you want us to do? Let's continue on now. The defendant Banks should be tried on all charges contained in the TSI. Defendant bears the burden of making a strong showing to justify severance. Severance is not warranted unless a joint trial would violate a defendant's substantive rights. A district court does not abuse its discretion unless a joint trial is so manifestly prejudicial as to require the exercise of discretion but one way, by ordering a separate trial. Serious consideration of judicial economy is appropriate. Here, a joint trial on all counts of the TSI promotes judicial economy and ensures the jury has before it the evidence necessary to evaluate this gang murder. As explained above, every count in the TSI incorporates the indictment's allegations regarding the racketeering enterprise, its object, and its manner and means. But even if the enterprise allegations were not incorporated into the murder for hire counts, the government's evidence, including defendants' admissions and anticipated co-conspirator testimony to prove the murder for hire conspiracy, is the same evidence necessary to prove Vicar, meaning it don't matter if this shit came in on a murder for hire, a RICO, a FRICO, a Vicar, a no car, bruh, all of this shit was gonna come in. Indeed, the Vicar murder charge wholly incorporates the Los Angeles murder for hire scheme because the Vicar purpose element is satisfied when a defendant commits murder, 1, to maintain a position within the racketeering enterprise, or 2, to receive something of pecuniary value from the enterprise. But y'all still can't explain what the hell that is. That's what's really pissing me off. My bad, y'all. And then prosecutors in the filing with Exhibit A. right here you can see where it says zoo, meaning y'all know who that is, and it says light. Who asks what's to us? I don't know what the hell that's supposed to mean, but whatever. Police question mark. Little dude, little brother. And then status is red. Benzu say 30 said ATF. So it goes on to say all of this crap, and then little dude, little brother. Delete thread and start new one. Then it say from Zoo. When y'all delete, click on that edit sign and clear all deleted too. It's the new update, so it won't stay in the cloud. And I guess this right here is from the messages, and I'm assuming this is some shit on the iPhone. That's why Ceddy Nash don't mess with iPhones. Instead of another page of legal arguments, they attach message screenshots. Police. 30 said ATF. Hell, delete thread and start a new one. That shit ain't gonna fly. Just gonna be honest with y'all. This does look bad because he even adds, when y'all delete, click on that edit sign and clear all deleted too. It's a new update, so it won't stay on the iCloud, or in the iCloud, technically. See, those are the last pages the government chose to leave with the judge as part of its argument to keep the entire case together. Durk is no longer just sitting there as an innocent person in a thread. They were able to find certain things. But I'm going to be honest with y'all. That don't mean shit. That don't mean a damn thing. People are looking at those messages and going, oh man, what were the previous messages? Shit, that makes you wonder. It is unclear what precise delay Defendant Banks asserts would be unconstitutional. Defendant Banks requested the continuance between November 2024 and October 2025, 11 months. And the time period between October 2025 and the current trial date, August 2026, was requested by his co-defendants with whom he is joined for trial, and no severance was granted, 10 months. Defendant Banks cannot plausibly contend that his first 11 months that he requested were unconstitutional, nor does he provide any case law that supports the purported unconstitutionality of the subsequent 10 months, all of which was requested by his co-defendants and authorized by the express terms of a Speedy Trial Act authorizing the continuance for a joint trial. Given the framing of defendant's motion, if the court does not sever the TSI, defendant Banks would not proceed to trial on August 20th. He appears to argue that any delay past August 20th, 2026 would be unconstitutional, but that assertion has no basis in case law. This is particularly true here, where the lack of a speedy trial act violated is evident, and they actually cite case law United States versus Nance. And it says, although no provision of the Speedy Trial Act is intended to bar any Sixth Amendment speedy trial claim, it would be an unusual case in which the time limits of a Speedy Trial Act have been met, but the Sixth Amendment right to speedy trial has been violated. Moreover, throughout this case, defendants have filed multiple motions that independently provide a basis for excludable time, including defendant Banks, multiple pretrial motions to dismiss, and the currently pending motion to sever, meaning you're putting all this stuff in here to slow us the hell down. So, court order continuing trial and finding that the time period from at least October 6, 2025 to the date of this order is excludable as to defendant Banks, Wilson, Houston, and Lindsay pursuant to 18 U.S.C. 3161 H1D due to the delay resulting from pretrial motions as set forth in paragraph 8B of the party stipulation. At its core, defendant Banks' motion hinges on his conclusion that any continuance would violate his rights because the delay would purportedly be based on government sandbaggery or gameship. But that is simply not the case. The government's decision to supersede was a good faith exercise of prosecutorial discretion that followed material developments in the government's investigation. After the government arrested and charged the defendants, it continued its investigation, including by searching over 38 digital devices and accounts. As the investigation continued, the government sought and obtained additional search warrants and issued other legal process leading up to the return of the TSI on June 3rd, 2026. To the extent defendant believed the investigation could have proceeded faster, defendant's own conduct significantly contributed to the investigation's complexity. Defendant to great lengths to conceal their criminality. They use coded language when discussing their criminal conduct. They use and dispose of multiple burner phones. They work to identify and intimidate witnesses who could or would cooperate against them. And they would delete and destroy evidence that could incriminate them, as evidenced by Banks' instruction to Enterprise members to delete the text thread and start anew after discussing someone who may have provided information to law enforcement. Additionally, defendants' argument that the government took the Chicago incident off the table when it withdrew its motion to admit it under Rule 404B breezes past material developments in that case. I knew they was going to do this shit. I knew it. Anyways, which contributed to the government's decision to include it as direct evidence. Basically, this shit was in trial and we had to wait for all of this stuff to come out before we would decide to use it. And it goes on, and I'm fairly certain, I haven't read this part right here, but I'm fairly effing certain that they're going to say this. Breezes past material developments in that case, which contributed to the government's decision to include it as direct evidence, not under Rule 404B, and the TSI motion at 1 specifically. In April and May of 2026, right, they're getting into what I said, the charged defendants in the Northern District of Illinois, United States versus Montgomery Wilson, pled guilty and admitted under oath that they murdered SM to collect a bounty payment from individual C. Evidence at trial will establish the murder as committed on behalf of the Banks Gang enterprise, including the text messages described above where the Chicago defendants discussed collecting a bounty payment from defendant Banks and OTF, photographs and video files seized from the Chicago defendants' digital devices, and a jailhouse confession by one of the Chicago defendants. This evidence not only shows a similar modus operandi to the Los Angeles murder of SR, it proves the operation in existence of a continual racketeering enterprise. While defendant Banks may be displeased with the government's decision to supersede and include the Chicago murder of SM as direct evidence of racketeering activity, defendant's preference that less evidence be presented against him does not amount to legal binding authority. But it's funny that y'all say that weak ass shit, because feds, y'all already knew this. Y'all just wanted them to sign on a dotted line, which I would argue y'all pressured them to do that. Now, the judge will decide whether prosecutors have done enough to defeat the motion to sever the counts or dismiss parts of the indictment. This filing isn't the judge's ruling, it's the government's response explaining why it believes the motion should be denied. The next move belongs to the actual court. And if you ask my opinion on it all, as once stated before, the judge is not going to sever a damn thing. One thing that we constantly, continuously say, it's not about what they're trying to say, like, oh, we're this part and this part and this part and not a part of the whole thing. The feds are essentially trying to say that, hey, y'all might not be the players that won this game, but y'all was still on the same damn team. And that's what it is. It's the feds trying to say Lil Durk is essentially, and this is just me helping people out to understand, it's as simple as possible, that there's a basketball team that exists. And this basketball team goes out and it does certain things. What certain things that it does? Well, murder, kill, rob, all of this shit. And not only that, it exists. They're saying, meaning everybody else like, nah, it ain't all this big ass goddamn group like y'all said. Or the Fed just said, yeah, it is. And I believe the judge is going to say, nah, F all that. Because the whole entire we need the speedy trial shit, you can't ask for a speedy trial, but then you ask for a continuation of evidence and now you want a speedy trial. It don't work like that, according to the feds. So we shall see. Subscribe to our Best Notified, share to keep your people aware. And y'all let me know y'all thoughts on this one. Click right here, though, to see how big Mr. Dare. Boy, this video funny as hell. I'm sorry. I don't want to ruin it. Just check this shit out right here or click right here for the playlist to get you through y'all day, and I will catch y'all in the next one.